Hello and welcome to LiveLaw Daily. I'm your host Debojit Das, and today, August 6th, is observed across the world as the Hiroshima Day. It marks the anniversary of the atomic bombing of Hiroshima in 1945, a day remembered not just for one of history's darkest moments, but also as a reminder of the devastating human cost of war and the continuing importance of peace, restraint, and the rule of law in resolving conflicts. With that, let's take you through today's biggest legal stories from courts across India. Our first story deals with the 2003 Muthanga land struggle case, where the Kerala High Court today raised serious questions about the way the trial court recorded its findings while convicting 4 people. The appeals were filed by social activists who were among the 57 accused prosecuted over the violence that broke out during the police eviction of Adivasi protesters from the Muthanga Wildlife Sanctuary in Wayanad. Just last week, the Sessions Court convicted the 4 of the offences, including rioting, unlawful assembly, causing injuries to public servants, kidnapping and attempt to murder, sentencing them to up to 5 years of rigorous imprisonment. The appellants have argued before the High Court that the conviction cannot stand because it relies on criminal conspiracy, even though the trial court itself described that finding as only prima facie. Justice Badruddin appeared concerned by that reasoning. During the hearing, he orally observed that if the trial court intended to convict someone, its finding ought to have been conclusive, not merely prima facie. The judge remarked that the Sessions Court judgment would require thorough scrutiny. To examine the issue further, the High Court directed the Sessions judge to send a copy of the charges framed against the accused, particularly because the appellants say that they were convicted with the aid of Section 120B of the IPC, despite what they describe as an inconclusive finding on conspiracy. The appeals will now proceed before the Kerala High Court, which will closely examine whether the trial court's reasoning can legally sustain the convictions. Our second story deals with accusations of rape against Tehelka's Tarun Tejpal, where the Bombay High Court today overturned a trial court judgment that had acquitted the former editor-in-chief and convicted him for more than a decade after the case first came to light. The case goes back to 2013, when a junior colleague accused Tejpal of sexually assaulting her during an event in Goa. The Goa police registered a case on its own after the allegations surfaced publicly. Tejpal denied the allegations throughout, claiming he was being politically targeted. After a lengthy trial involving 71 prosecution witnesses and electronic evidence including CCTV footage, emails and WhatsApp messages, a Sessions Court acquitted him in 2021, holding that there wasn't enough evidence to support the prosecution's case. The Goa government challenged that acquittal before the Bombay High Court. It argued that the trial court had wrongly focused on the survivors' conduct after the incident instead of examining the allegations themselves, and had failed to properly appreciate crucial evidence, including an apology email that Tejpal had sent after the complaint was made. A division bench of the Bombay High Court's Goa bench accepted the state's appeal, set aside the acquittal, and convicted Tejpal. During the sentencing hearing, Tejpal urged the court to be lenient, saying he believed he himself was a victim. Solicitor General Tushar Mehta, appearing for the state, argued that the case sent an important message that when a girl says no, it means no. The High Court has now sentenced Tejpal to 10 years rigorous imprisonment for rape under Section 376 subsection 2K of the Indian Penal Code, along with a fine of 5 lakh rupees. It also imposed separate sentences and fines for offences relating to sexual harassment, assault and wrongful restraint. Our third story deals with the long-running Shiv Sena split, where the Supreme Court today heard arguments on whether disqualification proceedings against MLAs can be allowed to remain pending indefinitely. The case has been filed by the Uddhav Thackeray faction, challenging the Maharashtra Speaker's decision not to disqualify Eknath Shinde's MLAs under the 10th schedule. Appearing before a bench of Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana, Senior Advocate Kapil Sibal argued that delays in deciding disqualification petitions only strengthen the position of the legislators facing them. Sibal pointed out that the Shinde faction began with 31 MLAs and has since grown to 39. Warning that if such cases remain undecided, the number could continue to rise. His argument was that people in power naturally attract more support, making prolonged delays unfair to the disqualification process. The bench also revisited the legal principles laid down in the Subhash Desai judgment. Justice Bagchi noted that the Constitution bench had already held that the political party and not the legislature party ultimately controls party affairs, and that a legislative majority alone cannot determine which faction is the real political party. At the same time, Justice Bagchi questioned parts of Sibbal's submissions on the sequence of events, pointing out that some decisions relied upon by him, including the appointment of a new party whip, took place only after the disqualification petitions had already been filed. Sibbal also cautioned against giving the Election Commission unchecked powers to disregard a political party's own constitution while deciding disputes over party control. The hearing will continue as the Supreme Court examines the Speaker's handling of the disqualification proceedings. Our next story deals with the Supreme Court granting interim protection from arrest to Sumit Roy, a close aide and personal assistant to Trinamool Congress MP Abhishek Banerjee in the Salboni land grabbing case. Sumit Roy had approached the Supreme Court after the Calcutta High Court rejected his anticipatory bail plea earlier this week. While hearing his petition, a bench of Chief Justice of India Suryakant, Justice Joymalia Bagchi, and Justice V. Mohana stayed his arrest for the time being, but directed him to fully cooperate with the investigation. The court said that he must appear for questioning whenever required, remain available between 10 a.m. and 6 p.m., and must not be accompanied by a lawyer or any other person during interrogation. Senior advocate Gopal Shankar Narayanan, appearing for Sumit Roy, argued that another high court had already granted him anticipatory bail in a separate cash for jobs case, and suggested that this FIR was registered only after the change of government in West Bengal, indicating political motivation. The state opposed any interim protection. Solicitor General Tushar Mehta argued that the alleged offence was an old one and that had not been acted upon by the previous government. He also insisted that custodial interrogation was necessary, alleging that attempts to arrest accused persons in similar cases had previously been obstructed by the former Chief Minister. Shankar Narayanan responded that political statements were being made in court. But for now, the Supreme Court has stayed Roy's arrest while allowing the investigation to continue, with the matter set to proceed after state files its response. Our next story deals with a Karnataka judicial officer who has now been transferred after the High Court came down heavily on her conduct in an alleged road rage incident. The officer, who is civil judge and judicial magistrate first class Gayatri, was accused of chasing two men on a motorcycle after they overtook her private car and then getting them arrested. The matter reached the Karnataka High Court through a petition filed by a 70-year-old man who sought to quash the criminal case registered against him following the incident. Last week, Justice M. Nag Prasanna made strong observations while hearing the case. Referring to the video footage placed before the court, he said it was wholly unbecoming of a judicial officer to get out of her car, quarrel with members of the public, and allegedly use her office after being upset that someone had overtaken her vehicle. The court remarked that if her ego had been hurt by the incident, it would amount to a classic example of abuse of judicial office. The judge also directed the High Court Registry to place the matter before the Chief Justice for appropriate disciplinary action. Following those developments, the Karnataka High Court has now issued a notification transferring Judge Gayatri from Malur to Humnabad and Bidar district, stating that the decision has been taken for administrative reasons and in the interest of public service with immediate effect. Our next story deals with the Bombay High Court's strong message to doctors over strikes, saying that patient care cannot be suspended no matter what the dispute is. The issue arose after the Indian Medical Association called for a nationwide 24-hour strike to protest the Maharashtra government's decision to allow homeopathy practitioners to register with the Maharashtra Medical Council. The High Court took suo motu cognizance of the proposed strike. And when the matter came up later in the day, the Indian Medical Association informed the court that it had withdrawn the strike, although it continued to oppose the state's decision. The association argued that a short bridge course should not place homeopathy practitioners on the same footing as MBBS doctors. But the bench led by Acting Chief Justice Ravindra Gughe made it clear that doctors cannot resort to strikes under any circumstances. The Acting Chief Justice remarked that even if doctors ultimately succeed in court, that would not bring back a patient who might have died because treatment was unavailable. The state defended its policy by saying that many MBBS doctors are unwilling to serve in rural areas, making the decision necessary. The bench, however, questioned that reasoning, observing that it was like allowing an undertrained pilot to fly a plane until it crashes. Since a separate challenge to the state's policy is already pending before another bench, the court refrained from commenting further on its legality. However, it appointed two amicus curiae to assist on the broader issue of doctors' strikes and directed them to prepare detailed submissions. The matter will now be heard again on September 8th. Our next story deals with a public interest litigation before the Kerala High Court that paints a troubling picture of governance in Lakshadweep, raising concerns that range from education and healthcare to livelihoods and agriculture. The petition alleges that several school buildings across the islands have been demolished, forcing students into a single overcrowded school. It has asked the High Court to order an independent technical audit to determine whether the remaining facilities even meet the standards prescribed by the state and the CBSE. It also claims that key industrial units run by the Lakshadweep Development Corporation, including a tuna processing unit and another production facility, have been shut down, affecting employment for many island residents. The petition further points to a super specialty hospital that, despite being established, is allegedly functioning without adequate doctors. A major grievance raised in the PIL concerns the functioning of the administration itself. It alleges that in the absence of the administrator, the bureaucracy, led by the advisor of the administrator, has been exercising powers arbitrarily. The petition cites instances such as the premature retirement of employees and alleges that officials have exceeded their authority in taking major administrative decisions. The public interest litigation also highlights the administration's handling of a widespread white fungus infection which affects coconut trees, arguing that the response has been inadequate despite coconuts being central to Lakshadweep's economy. The Kerala High Court will now examine these allegations and decide whether further directions or an investigation is warranted. Our next story deals with street vendors in Delhi and the sale of counterfeit branded goods, an issue that came up before the Delhi High Court. The case was filed by 24 street vendors seeking permission to sell in Karol, Bagh and Rajendra Nagar. But while hearing the matter, a division bench of Justice Pratibha M. Singh and Justice Vikas Mahajan noticed photographs showing vendors selling products carrying the names of brands such as Louis Vuitton, Zara, Puma and Calvin Klein. The court observed that if these products were counterfeit or being passed off as genuine, it would amount to an illegal activity, adding that while this wasn't the main issue before it, the court could not simply ignore it. The bench also found that several vendors were not operating as mobile vendors as required under the law and had instead occupied Ajmal Khan Road, which is officially notified as a no vending zone. The High Court has now directed the SHO of Karol Bagh Police Station to take action against the sale of counterfeit goods in accordance with law. It also made it clear that vendors cannot squat in no vending zones and must operate strictly as mobile vendors. Our ninth and final story deals with an important ruling from the Gujarat High Court on when a wife can be denied maintenance under Section 125 of the Criminal Procedure Code. The court clarified that simply because a wife fails to prove allegations of cruelty does not automatically mean she is not entitled to maintenance. Instead, every case must be decided on its facts and evidence. The case involved a woman who left her matrimonial home in August 2021. 2 days later, the couple executed a deed of divorce by mutual consent. She later sought maintenance, alleging that she had been subjected to cruelty and harassment. Her husband opposed the claim, arguing that she had left voluntarily and was living in adultery, which would bar her from claiming maintenance under Section 125, subsection 4. Justice S.V. Pinto noted that Section 125, subsection 4 bars maintenance in certain situations, including where a wife is living in adultery, where she refuses to live with her husband without sufficient reason, or where the parties are living separately by mutual consent. In this particular case, the High Court found that the family court had carefully examined the evidence and recorded a categorical finding that the wife had left the matrimonial home voluntarily and was living in adultery, and that the statutory bar under Section 125, subsection 4 therefore be applied. The court upheld that finding, holding that it disclosed no perversity or illegality warranting interference. At the same time, the High Court stressed that this should not be treated as a general rule. Whether a wife had sufficient reason to live separately, it said, must always be decided on the evidence in each individual case. And that's all we have for you in today's edition of LiveLaw Daily. If you'd like to read any of these stories in greater detail, you'll find the links in the description box below. If you found this roundup useful, don't forget to subscribe to LiveLaw on YouTube and follow us across our social media platforms. Thank you for listening. I'll see you tomorrow.